The other day I heard a man say he didn't believe in God's word. But truly I can say that God has made a way, and he'll never fail me yet. Come on, sing it! Leaning on, yeah. Trusting in, yeah. He never failed. So we sing. So we sing, If anybody asks you who I am, who I am, who I am, if anybody asks you who I am, just tell them I'm a child of God. Yeah. Who I am, who I am. Anybody ask you? Yeah. Just tell them.
If anybody asks you who you are, who you are, who you are, anybody asks you who you are, tell them you're a child of God. Sweet the sound, how sweet that sound, amazing grace, how sweet the sound that saved a wretch like me.
My Father is rich with houses and land. He ruled the world in the palm of his hand. Rubies and diamonds, silver and gold. Tell him I'm a child of God. Yeah. Who I am, who I am. Anybody ask you? Yeah, yeah, yeah. Tell
Amazing grace, how sweet that sound, how sweet that sound, how sweet that sound. Amazing grace, how sweet that sound that saved a wretch like me.
my Father is a rich man, houses and land. He ruled the world in the palm of his hand. Rubies and diamonds, silver and gold. Tell him I'm a child of God. Come on, sing it. Who you are, who you are. Anybody ask you? Yeah, yeah, yeah. Tell him. Who I am, who I am. Anybody ask you? Yeah, yeah, yeah. Tell them I'm a child of God.
I'm a child of God.
Through danger seen and unseen, there's protection all around. Under the refuge Should the shadows come, why should my heart feel lonely? Long for heaven and home. When Jesus is my portion, a constant friend is He. His eyes on that sparrow, and I know He watches me. I sing because I'm happy, and I sing because I'm free. His eye is on that sparrow, so I know He watches over you and me. Let not your heart be troubled. His tender words I hear, and resting on His goodness, I lose my doubts and my fears. Though by the path He leadeth, but one step I may see, I know His eye is on that little sparrow, so I know He watches me. So I'll sing because I'm happy, and I will sing because I know I'm free.
a sweet, sweet spirit in this place, and I know that it's the Spirit of the Lord.
There are sweet expressions on each face, and I know that it's the presence of the Lord. Come on, sing, yeah, yeah. Sweet heavenly dove, stay right here with us. Oh, filling us with your love. Yeah, yeah, Lord. We lift our hearts in prayer. Yes, we do. Yes, we do. Without a doubt. Hey. We've been when we shall be despair. Sweet heavenly dove, stay right with us. Oh, stay right with us, Lord, filling us with your love. Oh, yeah. Hey. We lift our hearts, lift our hearts, lift our hearts in praise without a doubt that we'll be here.
It's so unfair. I have to follow the choir. You know, that was amazing. Every year, it is such a joy to hear from that group of talented and spirited folks who are here with us today. My name is Troy McKenzie. I have the honor and the privilege of being the Dean of NYU School of Law. And it is with delight and with humility that I extend a warm welcome to everyone, our distinguished guests, our students, faculty, friends, and others here in our community to commemorate the legacy of the great Derek Bell. The Bell Lecture is one of the most highly anticipated moments of the academic year here at NYU, and it is a special way for us to remember and to celebrate Derek's extraordinary contributions to the law throughout the United States and the world, and also to our community here at NYU. And throughout his life, he shared his wisdom, his passion at a number of law schools, but he found his home here at NYU Law, and we are profoundly honored that he did. His sense of integrity, his sense of principle permeated every aspect of his career. from his pioneering role at the Civil Rights Division of the U.S. Department of Justice to his role at the NAACP Legal Defense and Education Fund under Thurgood Marshall. In recognition of his many years of extraordinary teaching and mentorship here at NYU, he was honored posthumously with the law school's Distinguished Teaching Award in 2012. And I can't emphasize enough the impact that he had on us here at NYU. The mission, and it is a mission of this lecture series, is to examine the role of race in American society, and for nearly 3 decades it has provided a platform for the critical study and analysis of that topic by scholars and activists who have come to share their insights on racial justice and civil rights. I want to thank Kristen Henning for being here this evening. We are honored to have Professor Henning as this evening's lecturer. She is the Bloom Professor of Law and Director of the Juvenile Justice Clinic and Initiative at Georgetown University Law Center. She has dedicated more than 2 decades to defending young people in the juvenile justice system, and she has had a profound influence on the field. She will present her lecture, The Rage of Innocence, Decriminalizing Race, Adolescence, Trauma, and Disabilities, in a few moments. But please join me again in welcoming Professor Henning here. I want to say a few words about the Center on Race, Inequality, and the Law, which has now become an integral part of the Bell Lecture. The center is a testament to Derek Bell's vision, and it continues his legacy by offering courses and resources to scholars and students addressing subjects related to race, ethnicity, and inequality. I want to express my gratitude to the center's leadership, to Faculty Director Vincent Sutherland, my colleague, and Executive Director Jason Williamson for their exceptional work that I don't think I need to say to everyone here, but I will say is even more important today than it was not that long ago. I also want to thank our NYU Law Alumni of Color Association, LACA, for their support over the years for this lecture series. I want to say a special thanks to the president of LACA, Rafiq Kalamuddin, my classmate, and to our law trustee and longtime LACA supporter, Lisa Boykin. Lisa was a protege of Derek Bell, and her work to keep his legacy vibrant has been invaluable in our community. Now, before I close, there is another important thing I want to mention, and that's CLE credit. This event has been approved for 1 New York State CLE credit in the category of professional practice. If you are seeking CLE credit, please be sure to sign in and to sign out at the registration desk just outside of the doors to Greenberg Lounge. Now, I would like to introduce Derek's widow, Dr. Janet Dewart Bell, a longtime friend of the law school, a longtime member of our community, and the person who conceived the Bell Lecture as a birthday present to Derek. Dr. Bell's professional and personal commitment to justice, to equal rights, to education, to communication is exceptional. Her career as a social justice activist is marked by an enduring dedication to volunteer service, to promoting initiatives that increase diversity and equal rights for all. She is a dynamo. She is the Energizer Bunny. She is the person who I always look to when I want to get a little boost. And today, and for some time now, it's been nice to get a little boost. And I want to thank you, Janet, for your amazing work and your amazing spirit. She is the author of Lighting the Fires of Freedom, African American Women in the Civil Rights Movement, and is co-editor with Vincent Sutherland of Race, Rights, and Redemption, the Derek Bell Lectures on Law and Critical Race Theory. So I want to thank everyone again for being here, and I would like to welcome Dr. Bell to say a few words.
Good evening, everyone. I, of course, want to thank Dean Troy McKenzie, whose incredible institutional support is very heartwarming and almost overwhelming. And I want to thank him personally for his graciousness and personal support. Derek lived to teach, and teaching kept him alive. For him, it was always students first. That was a mantra in our household. In that universal encyclopedia, his portrait is next to the definition of mentor. For him, there was no higher calling than teacher. It is always gratifying and humbling that students who never met him in person are very much his students, continuing to carry on his work with integrity and dedication. Derek was a strategist who gave us a playbook. He was a patriot, a war veteran, a true gentleman and scholar. While his prophecies were sometimes dire, he did not give in to cynicism and despair. We lived joy in the midst of struggle. He always kept hope alive. I'd like to acknowledge the three Bell sons, two of whom are here tonight, Derek Bell III and Carter Bell, Carter Robeson Bell. Douglas Du Bois Bell is not able to join us tonight, and yes, there is significance in those names. As the family wit, Carter notes that he has 3 last names, Carter being in honor of Derek's mentors, Robert L. Carter and his wife, Gloria. The late Judge Carter argued the first Brown v. Board of Education case before the Supreme Court and taught at this school. Derek's other mentor was the late civil rights attorney and judge, Constance Baker Motley, whom he assisted in the integration of the universities of Georgia and Mississippi. I especially want to lift up the memory of Derek's first wife, a phenomenal woman if ever there was, Jewel Hairston Bell, who died before Derek and I met. As partners, she and Derek set the standard. Now, almost 30 years ago, the Bell Lectures co-founders shared a dream with me. They were Judge Robert L. Carter, Paulette Jones Robinson, and Valerie Kavanaugh and William Kerstetter. Valerie Kavanaugh comes every year from California. Stand up, Valerie. I came up with this insane idea about 6 weeks before the event took place, and I called Valerie, who gave me the seed money to pull it off. So thank you. In our village is the international lawyer Alice Young, Oh, come on, don't be shy, y'all. We don't have time, stand up. One of Derek's first students at Harvard. She, along with the Harvard professor and Bell student Charles Ogletree, helped endow this series, with recent assists from Kitty Muldoon Steele and Lewis Steele. I have deep personal thanks to former dean and university president John Sexton, a Bell student at Harvard, who championed this lecture series from the beginning, and to John's successors, former deans Ricky Revesz and Trevor Morrison. And as Dean Troy McKenzie said, I'd also like to thank LACA, the Law Association of Color Association, and its president. LACA also, in addition to supporting this lecture series, provides scholarships in Derek's name. Go LACA. This event would not be the spectacular event it is. Y'all agree with me? It's spectacular so far? It's getting better when I get down. Without the Office of Development and Alumni Relations, I want to thank them for their care and attention to this lecture series. Thanks especially to Senior Director Ellie Fallon and Associate Director Alyssa Ward. On behalf of the Bell extended family, we pledge continued commitment to this wonderful, exceptional law school, represented in part by this lecture series and the courtyard bench with a plaque in Derek's honor. A plaque and a bench to renew your commitment to defend what is our fragile democracy. Derek also donated his archives to NYU, and we encourage students and other scholars to mine the many treasures they contain. And this is one of my favorite parts. Many of you know that Randy Hertz is my ride or die. I'd like to thank the brilliant, kind, and humble Vice Dean Randy Hertz, who is the faculty liaison for the Bell Lecture since Derek's passing. I could not have done this without Randy. Students love Randy. As with Derek, Randy Hertz is student-focused and a little student-obsessed. He, like Derek, is truly a gentleman and a scholar. The Bell lecturers have been consistently wonderful and diverse. Stellar scholars. Tonight's lecturer, Professor Kristen Henning, is no exception. She will be introduced by Jason Williamson, but I want to say a few words about Jason Williamson, who is the Executive Director of the Center on Race, Inequality, and the Law. Prior to assuming his current role in June 2021, Jason spent more than 20 years as a staff attorney and deputy director of the ACLU's, support that organization please, Criminal Law Reform Project, where he focused primarily on Fourth Amendment, police practices, and public defense reform litigation. Prior to joining the ACLU, Jason worked as a litigation associate at Paul Weiss and served as a law clerk for Judge Sterling Johnson in the Eastern District of New York. You will hear from Jason later, but before you hear from him, we have to go back to the choir from First Presbyterian Church, Brooklyn. I started the series, but Derek started the choir. He said, any event that we have, I want music. Those of you who took his classes at NYU, he had music. He had class songs. I mean, really? And so it's a birthday celebration as well. The Bell Lecture is held every year around Derek's birthday on November 6th. And it was the day after for many of us, but we march on. We never give up. We never give out. We never give in. So I'm going to invite the First Presbyterian Choir and their guest pianist and soloist tonight, Professor Kendall Thomas from Columbia University, who will now play Happy Birthday. Yes, the Stevie Wonder version. Yes. Happy birthday to you. Happy birthday to you. Happy birthday. Happy birthday to you. Happy birthday to you. Happy birthday. 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 Happy birthday to you. Happy birthday to you. Happy birthday.
Good evening, everybody. Thanks so much to Dr. Bell. Thank you to Dean McKenzie. So grateful to be here. Honored, really, to help celebrate the life and work of Professor Bell, whose incredible contributions to racial justice scholarship have impacted so many of us in this room and beyond. I also want to thank the Center's faculty director, Vincent Sutherland, who you've already heard about tonight, for his tremendous support and guidance, and for his vision for this center as its inaugural executive director back in 2017. I also want to thank my amazing colleagues at the center, Staff Attorney Tolu Lawal, Legal Fellow Juna Seamus, Operations Coordinator Layla Al, and Distinguished Scholar in Residence Justine Olderman, who we were thrilled to have join us this fall. And I want to express my gratitude to our 6 student fellows as well, who do so much to increase our capacity throughout the school year. So to Mahalia Methalir, McKenna Mugambi, Caitlin Fernandez, Sanzita Ahmed, Ernesto Casillas, and Mugda Garam, thank you so much for everything that you do. The Center on Race, Inequality, and the Law was created to confront the laws, policies, and practices that lead to the oppression and marginalization of people and communities of color across the country. We aim to document the history and ongoing perpetuation of racism in the United States, to elevate the stories and experiences of impacted people and communities, to collaborate with community-based organizations and activists who are fighting back against discriminatory policies and practices in their communities, whether perpetrated by the government or by private actors, and to always work and always do our work through a racial justice lens so that we never lose sight of the role that race and the legacy of slavery play in shaping our individual and collective experiences across all sectors of our society. And while racial justice advocacy is, of course, a sprawling endeavor, we focus our attention primarily on race discrimination within the criminal legal system, the intersection of race and technology, social and economic justice, and the role of legal education in our broader work. To further those efforts, we engage in a range of activities, including impact litigation, individual representation of incarcerated people seeking parole in New York State, policy advocacy, organizing, public education, coalition building, and co-sponsoring events like these that create space for racial justice scholars to share their work and expertise and to help us grapple with the hard realities of race in America and how we can ultimately win, or at least make progress in the fight for justice. Now, Troy alluded to this, and I understand we are a nonpartisan institution, but I think it is worth noting that our center, along with the Meltzer Center for Diversity, Inclusion, and Belonging here at the law school, were created in 2017. In fact, the launch event for our center occurred in February of 2017, less than a month after the inauguration of Donald Trump. And in many ways, the centers were created in direct response to the election of Donald Trump and what many expected to be a full-on assault on civil rights and civil liberties that would wreak havoc in communities of color in particular. And we were right. And here we are, 8 years later, confronting what Professor Bell likely would see as yet another reflection of the permanence of racism in American society. We are again on the verge of a Trump presidency that promises to make the fight for racial justice even more challenging than it already was. And so, in this historical moment, our work is more important than ever. We will endure, and we will do our very best to meet that moment with renewed strength and an unwavering commitment to our cause. So with that as the backdrop, we are so grateful to be joined by our esteemed guest lecturer, Kristen Henning. You've heard a little bit of her bio, and it's in the programs on your seat, but I'm going to read it aloud anyway, because it's that impressive. Professor Henning is the Bloom Professor of Law and Director of the Juvenile Justice Clinic and Initiative at Georgetown Law. Professor Henning has been representing children accused of crime for more than 26 years and was the lead attorney for the juvenile unit of the DC Public Defender Service. She's currently the director of the Mid-Atlantic region of the Galt Center. Professor Henning worked closely with the MacArthur Foundation's Juvenile Indigent Defense Action Network to develop the Juvenile Training Immersion Program, a national training curriculum for youth defenders, and is co-founder of several initiatives to combat racial inequalities in the juvenile and criminal legal systems, including the Ambassadors for Racial Justice Program and a Racial Justice Toolkit for defenders. Professor Henning trains state actors across the country on the impact of racial bias in the courts and the traumatic effects of policing in communities of color. Professor Henning writes extensively about race, adolescence, and policing, and her book, The Rage of Innocence: How America Criminalizes Black Youth, published in 2021, was featured on the front page of the New York Times Book Review. Professor Henning serves on the board of directors for the Public Welfare Foundation and has previously served on the board for the Center for Children's Law and Policy, and was an advisor to ALI's Restatement of the Law, Children and the Law Project. She's received many awards, including a 2023 Embracing the Legacy Award from the RFK Community Alliance, a 2022 Women of Distinction Award from the American Association of University Women, the 2021 Leadership Prize for the Juvenile Law Center, and the Robert E. Shepard Jr. Leadership Award for Excellence in Juvenile Defense by the Galt Center. Professor Henning earned her BA from Duke University, her JD from Yale Law School, boo, kidding, and her LLM in advocacy from Georgetown Law. And so, without further ado, I give you Professor Kristen Henning.
Thank you. so much. I will say it is an absolute honor and privilege to stand in the honor of Derek Bell's legacy. Derek Bell, whose courage and activism and scholarship paved the way for so many of us to think about, to talk about, and to write about the intersection of race and the law. And so I really want to say thank you to Dr. Janet Bell, just for your graciousness. In the short time that I've met you, just your spirit is just so warm and so kind, and so I just thank you personally. But I thank you also for creating this beautiful space, not only to honor your husband and his work, but also for your own work. Right, elevating, highlighting the women of the civil rights movement, and for creating space for folks like us to come and to talk about race and the law. So I really thank you for that. I also thank you, Dean McKenzie, for hosting this wonderful evening and inviting me. It's wonderful to finally meet you. I've heard so much about you. We have a number of mutual friends, and so it's great to meet you. I also want to thank Professor Jason Williamson for that wonderful introduction, but also for your leadership in the Center on Race, Inequality, and Law. Similarly to Associate Dean Deborah Archer, my dear friend, Vincent Sutherland, my dear friend, for your leadership in racial justice. And I also have to say that whenever I come back to NYU, I feel like I'm coming home, notwithstanding the booze, not on the Yale front and on the Georgetown front. The reality is I have a lot of friends here, and I feel very much at home. In fact, Deborah Archer and I were neighbors in law school that you all booed at. I'm just outing her, right? I'm outing her. But we were neighbors, and I have to say, she was in the class behind me, and when she showed up, we knew she showed up with fire, and that has absolutely been the case. Vincent Sutherland was a Prettyman Fellow at Georgetown, and similarly, his excellent advocacy skills and leadership were evident from day one. I have to give a shout out to Marty Guggenheim, who I haven't seen yet. There he is, right here. Great to see you. And Randy Hertz for their leadership and mentoring, supporting, guiding so many of us in the areas of children's rights and family law. And I have to say to Dr. Bell, Randy Hertz is the ride or die for everybody, right? So, you know, it is so true. Randy Hertz is unequivocally has meant so much to me personally and professionally. He has been a cheerleader, a confidant, a colleague. We actually co-taught together here at NYU when I was a visiting professor. I hope I get a little applause. But indeed, we co-taught together, and you all allow me to borrow Randy every single year. I get the joy of spending an entire week with Randy at Georgetown Law School when he comes to help us train our national community of youth defenders at our annual summer camp. So I just really, really want to appreciate him. But tonight, I want to honor Derek Bell with reflections on the state of Black youth in particular in America. In 2018, Michelle Alexander described Derek Bell's book, Faces at the Bottom of the Well, as eerily prophetic, almost haunting, as a piece of work on American racism and the struggle for racial justice. As I stand before you on November 13, 2024, just over a week after what is one of the most important elections, at least in my career and lifetime, the words eerily prophetic and almost haunting could not be more accurate. I found myself thinking about what Professor Bell might say in a moment like this, and I suspect it might be something like, you couldn't possibly be surprised, right? You knew this was coming. But I also suspect that he would remind all of his students that he cared so much about the words he shared in his NPR interview in 1992. In all of my courses, I really have to teach the basic messages of my life, that the rewards, the satisfactions, are not in being partner or making $1 million, but in recognizing evils, recognizing injustice, and standing up and speaking out about them, even, and this is my editorial, what appear to be absolutely losing situations, where you believe that it's not going to bring about any change. Yet there are intangible rewards to that spirit of speaking up and speaking out and standing up that make it worthwhile. So as I stand here, I had to allow myself to recognize that it's okay if we don't have all of the answers right now, if we don't have the strategy outlined step by step right now, and even if we aren't completely healed from last week, we have to put one step, one foot in front of the other and speak from whatever seat we occupy in society. And so I have to say that I can think of few mandates as important as the need to create a country, a state, a series of individual relationships in which every single child, regardless of race, regardless of class, religion, regardless of who they love, has a right and an opportunity to be a child in this country. So, as Professor Williamson said, I have been representing children in the nation's capital in delinquency and criminal cases for the last 26 years. But what is shocking about that is that in that entire 26 years, I have only represented 4 white children. That is it. Every other child I have represented has been an African-American child. And those of you who aren't familiar with the District of Columbia, which is probably none of you, right? That 90 might believe that 99 to 1% ratio suggests that there are no white children in the nation's capital, or that white children don't commit crime. I'm here to tell you that neither of those would be true, right? And so it is not hyperbole to say that our nation's obsession with policing and incarcerating Black America begins with Black children. It's no coincidence that so many of the most highly publicized allegations of Black threat, followed by the horrific acts of violence against Black people, have involved adolescents. The Scottsboro boys were the ages of 13 to 19 years old in 1931 when they were falsely accused of raping 2 white women in Scottsboro, Alabama. George Stinney was the youngest person ever executed in 20th century America at the age of 14 when he was also accused of murdering 2 white girls. Emmett Till was 14 in 1955 when he was lynched for allegedly harassing a white woman in Mississippi. And James Hanover Thompson was 10 years old in 1958 when an 8-year-old white girl kissed him on the cheek. In North Carolina, later James was hunted, beaten, and charged with molestation. There is something particularly efficient about dehumanizing, exploiting, criminalizing, and even killing Black children to establish the boundaries of whiteness before they reach adolescence and begin to assert their own independence. And so much of that criminalization occurs in our nation's schools. So it is important to just pause for a moment and think about the structures and the systems that make that possible. And so I should tell you that I for far too long, bought into the often repeated narrative that we have police in our nation's schools today because teachers and parents were afraid to send their children back to school after the shooting in Columbine, Colorado, right? But the reality is, if we look back, the police first appeared in our nation's schools in Indianapolis in 1939 in response to the earliest inkling of even the possibility of a conversation about integrating schools. And then fast forward to the civil rights era, and we see that police presence in schools increased exponentially, right? Under the guise of creating a safe passage for Black and brown children to integrate schools. But we know from the iconic photographs and the historic record that police were more of an impediment, right, to meaningful integration of schools. And then fast forward again to the mid-1990s when the federal government launched the Cops in Schools program in 1994 to pour federal dollars into state and local schools that would agree to hire police in schools. And to be clear, there were already so many school resource officers by 1994. In fact, by 1991, the National Association of School Resource Officers was founded. We are 8 years before the Columbine shooting. And what else was already happening by 1999 in our country? We know that Black youth were being demonized by the super predator myth that claimed that Black youth would run amok and rape, maim, and kill all of America by the year 2000. Now, we know that never happened, and Professor John DiIulio, who coined the phrase, the term super predator, had to recant a year later, but the damage was already done. Black youth had become the principal targets in the war on crime as politicians realized that they could exploit race and crime for their political advantage. And then the narrative of Black youth as brute, as thug, as a threat is now so well established that many people, even egalitarian thinkers, are afraid of Black children where they see them on the street, in the park, and on public transportation. So I think everyone in this room knows that America has a long history of failing to recognize Black children as children and of failing to grant Black youth the benefits of adolescence. But what many of us don't know, and I actually didn't know until I did research, is that the concept, the social construct of adolescence is actually a relatively new phenomena in our country. Adolescence was actually invented by the white middle class parents to give their children an advantage in the workforce after the Industrial Revolution. Adolescence now includes an extended period of education, a prolonged season of self-discovery, recreation, fun, leisure, right? Adolescence has a value. It is a privilege. It is a commodity. And drawing from the wisdom of Professor Cheryl Harris, it is like whiteness. It's like property, right? Now, Black youth were denied the early privileges of adolescence because they needed to work often or were excluded from schools in our country. But now, even when we have compulsory school attendance laws and labor laws that protect all youth, Black youth are still excluded from the privileges of adolescence through what I call the criminalization of normal adolescence. So what does that look like, right? What does that look like today in real time? Well, it looks like my client, Sharice, all right? And I call her Sharice for purposes of our conversation today. But Sharice was a 17-year-old Black girl in Washington, D.C., who got into an argument with her boyfriend at school. During the course of the argument, she became convinced that her boyfriend was cheating on her. So she reached out and she grabbed his cell phone and began to walk away down the hall. As she's walking away, she's scrolling through his text messages to see who he's been communicating with. Well, a school resource officer sees this and decides to intervene. A little call and response since we've had church. What do you think he did? He arrested her. He arrested this child in the hallway in front of her teachers, in front of her classmates. The local police department came and picked her up. She's held in secure detention overnight, brought to court the next day, and formally prosecuted for robbery, taking the property of another by stealth or force. Now, whenever I talk about the prosecution and detention of youth in juvenile and criminal courts, people automatically assume that I must be talking about serious violent felonies, right? Rape, carjacking, murder, violent assaults, and real robberies, not that one, right? But this is far from the truth. The data is clear that few children of any race and any class are engaged in the type of violent behavior that we see on the news and might be legitimately afraid of. That's not what makes up most of what we see in the courts. Instead, juvenile courts are populated by children like Sharice, right, who have engaged in some behavior that arises out of the key features of normal adolescence. And I could ask you, we're at a law school. I could do a little Socratic method, right? I could ask you, what do we know about teenagers? What do we know about teenagers? We know they are impulsive, reactive, emotional. They're fairness fanatics, exactly as Sharice was, right? Sensation seekers, risk takers. Peer influence is not a myth. They do not only what their friends do, but also what they think their friends are doing. And they care more about the immediate rewards and don't think ahead to the long-term consequences. But here's the thing that's most important in our conversation about the intersection of race and adolescence is that the research makes clear that teenagers act like teenagers wherever they live and whatever they look like. Youth of all races and classes and ethnicities experience those same key features of adolescence. Empirical research bears this out. There's no good adolescents and bad adolescents, no black adolescents, brown adolescents, there are no white adolescents. It's just adolescence. Now, yet, notwithstanding that, right, racial disparities are evident all over the United States. And even as referrals to juvenile court have gone down, contrary to what people believe in the news, right? Although youth referrals to juvenile court have gone down, racial disparities have gotten broader, right? Deeper. Even when we get annoyed at the recklessness of adolescence, for the most part, we still treat teenagers, most teenagers, right, with tolerance and grace and compassion and forgiveness and redirection and sometimes just downright humor. Think about all of the adolescent films we see coming out of Hollywood, right? But yet, black children are criminalized for virtually everything that is a key feature of adolescence. And I often ask folks to think about, what did you care most about when you were a teenager? And what you see is that black children are demonized and criminalized for the things we cared about. The clothes that they wear, the music that they listen to, the way they style their hair, playing on a cell phone in class, going to parties, coming home after curfew, experimenting with drugs, sex, and alcohol, which I know none of you did, right? But the reality is actually you did, and you came out just fine, more than just fine. You're sitting here honoring Derek Bell on a beautiful day like this. We did these things, and we are okay, right? And we could really pull the thread on any of those if we think about music, right? Children, white children listen to country, heavy metal, pop music, rock music with the same misogynistic themes, the same glorification of violence, drugs, sex. All of it is there. virtually without consequence. We talk about black children listening to hip hop and to rap music as if they are the most dangerous children alive. Right? We think about pulling the thread on clothing, and we think about historically how children, how, let's put it this way, we have never outlawed, right, bell bottoms and tie-dye t-shirts. I love this crowd. You're laughing already. I haven't even finished. Right? That were commonly associated with hallucinogens and weed, right? We have never outlawed the all-black attire and straight black hair, of course, that were commonly associated with the goth fashion statement, but also commonly associated with mass shootings. We've also never outlawed the steel-toed Doc Martens with red shoelaces, which some young white supremacist groups have self-identified as their fashion statement. We've never done that. Yet, what we have outlawed in some places across the country is sagging pants. And I always say to people, I have no desire to see anybody's underwear, let's be clear. But is it grounds, is it appropriate basis upon which to justify the stop of a young person by the police officer and leading to an encounter that goes from 0 to 100 in an instant? Right? And then think about the black hoodie. Even if it's not outlawed on the books, it is the symbolic representation of black threat in our country, the hoodie. Now, much of what I have talked about so far is about normal adolescent behaviors, but I really want to highlight that even when black children do engage in serious violent offenses, we treat them as if they are beyond redemption. We're more likely to prosecute them as adults, more likely to find them guilty, more likely to impose severe sentences like life without the possibility of parole, and more likely to hold them in solitary confinement. Contrast Kyle Rittenhouse. Need I say more? 17-year-old child walking about with a assault rifle strapped on his body in public and doesn't get stopped. He then kills 2 people, severely injures another, and not only does he get a trial with all of the protections of due process, but he also gets found not guilty. While Tamir Rice is shot and killed in less than 3 seconds of the police arriving and seeing him with a toy gun in a park. So why did the officer respond to my client Sharice in the way that he did? And why are black boys like Tamir so much more likely to experience the violence of the police? Well, there are certainly multiple layers to that answer, but a significant part of it lies in the ways in which we in our country, or the ways in which our racial bias shapes our perceptions and our responses to adolescence, right? And particularly to black adolescents. So research shows that adults are more likely to view black girls as older, more mature, more adult-like, more knowledgeable about adult topics, less innocent and less in need of protection than similarly situated white girls. Similar research has been done involving black boys, showing that adults tend to perceive black boys like Tamir Rice as significantly older than they actually are. In fact, more than 4.5 years older than they actually are. So you think about a 12-year-old Tamir Rice, and they're seeing him as 17 and 18. You even think about Mike Brown. I write about Mike Brown, and somebody says, "Oh, why did you include Mike Brown in your discussion of adolescence?" He was 18. How many of you all know that 18-year-olds are still every bit of adolescence, right? But he was called a monster and a brute, right? People want to emphasize this perception of him and other black boys being older. And in fact, research shows that folks perceive black boys, young black boys, as stronger, taller, heavier, more muscular, more physically threatening, more capable of harm than a white male of the exact same height and the exact same weight. And then look at these photographs, right? And even we have to ask ourselves, even in a space like this, are you afraid of these kids, right? Are you afraid of these kids? Are you afraid of these kids when you see them in the park? Notwithstanding how we think we would react in the moment, the research actually shows that Black youth in a group are more likely to be stopped, frisked, searched, experience some use of harm by the police. And this isn't just a police story. It's also the story of who's calling 911 to report these kids, right? On the street or in the park. And as we continue to think about how this criminalization occurs, I really want to add another important, often overlooked layer to the criminalization of youth of color. Many of you who work with young people will not be surprised to learn that my client, 17-year-old Sharice, who was arrested for taking her boyfriend's cell phone, had a learning disability, right? And emotional distress that caused her to overreact when she felt like things were out of control. Students like Sharice with various types of cognitive, emotional, developmental, and other learning disabilities often have a hard time communicating their fears, communicating their needs, and following instructions by folks like teachers and law enforcement officers. A young person with a disability might curse, they might yell, they might even throw something when they're anxious and they're frustrated and they don't have the words, right, to share those experiences. Children with cognitive communicative disorders have a hard time processing the WH words, who, what, where, when, and why, and especially when they're fired at them in the way that we do as adults. Where are you going? Where are you supposed to be, Sharice? Why aren't you there? Why are you talking in class? And then young people with on the autism spectrum often have a hard time with executive functioning, which affects their ability to engage in problem solving, reasoning, to tap into their working memory and their task management. All of this increases the likelihood that a child will be punished and criminalized for their disability. And indeed, the data bears this out. Students with disabilities are significantly more likely to be disciplined and arrested at school. And of course, you know where I'm going next. All of this is magnified for youth of color with disabilities, who are even more likely to be disciplined and arrested when adults misunderstand and misinterpret their outbursts and behaviors associated with disability, but they see them as violent, aggressive, and criminal, based on all of the stereotypes and biases that they bring into that encounter. And for the sake of time, I will skip most of the statistics, but it's all here if you want it. Suffice it to say that Black youth served under the Individuals with Disability the Individuals with Disability in Education Act account for only 2.3% of the total student population. However, they account for 8.4% of students referred to law enforcement and 9.1% of students arrested. That is a powerful reality. Now that we understand some of how this criminalization occurs, it is even more important for us to understand the impact of that criminalization on Black youth. Every single time we call the police on a child or rely on some other punitive law enforcement intervention, that has a significant impact on the child's mental health, physical health, developmental trajectory, psychological well-being, and their academic success. There is a growing body of research demonstrating the extraordinary psychological trauma that young people, especially Black and Latino youth, experience in the presence of police during these most critical years of their lives, their adolescent years. Studies show that Black and brown youth who attend heavily surveilled schools like Sharice, or who live in heavily surveilled neighborhoods, or who have been the target of significant stops and frisks, report high rates of fear, anxiety, depression. They become hypervigilant. not trusting police. And that distrust of police carries over to other adult authority figures in their lives. Teachers, counselors, mentors who might be allies for them. And what's so powerful about this research is that it shows that this trauma occurs not only by being the direct target of that contact, but also by witnessing or hearing about it among friends, family, people that they're close to, right? Or even watching it on the internet and the television. So just having to worry, getting up in the morning and just having to worry about becoming the victim of police violence is in and of itself a source of stress. And I could tell you story after story about young people who we represent in Washington, D.C., who live in this perpetual fear and anxiety of coming into contact with the police every day. And then one of the most important ways in which policing impacts adolescents is in adolescent identity development, which is just a fancy way of saying that frequent police interventions affect the ways in which young people, right, see themselves, think about who they are, who they can become, and how they fit into society. Adolescence is the time in our lives when our views about law and law enforcement become fixed in our brains. And so those early negative encounters have a profound impact upon the ways in which we engage with law and law enforcement in the future and cause many young people, especially young people of color, to question the fairness and the legitimacy of policing as an institution. And in the final trauma study I want to share with you is research that shows something that I think will be intuitive to most of us in the room, which is that extended periods of psychological stress and trauma, chronic stress, right, have a significant impact on one's physical health. So that young people who are living in these heavily surveilled contexts are more likely to experience high blood pressure, diabetes, stroke, ulcers, cognitive impairments, early deaths, and the like. So what do we do about that? And so I have to say that I have a standard set of answers, right, of solutions, if you will, that I often give in conversations in reform-minded spaces like that, like this. And many of them still stand, right? But I recognize in this moment that many of them just won't do, right? Either in the short term or in the long term. And like I suspect many of you in this room, I am a proponent of abolition. And I am waiting for the revolution, especially right now. But I can tell you this, that when I go back to court tomorrow, there will be more black children, more brown children who have been arrested. There will be more black and brown children who need me and my law students and folks like you to stand up for them in court and wherever they are. I can tell you that these children cannot wait for the revolution. They cannot wait until we rise up a third party in the political landscape. They cannot wait until we abolish the juvenile and criminal legal system and its prisons and its police officers. Those children need us now. And so my comments tonight really focus on what the children need from us today. Our children still absolutely need us to advocate for racial justice and for justice writ large in the legal system that still exists and is not going anywhere anytime soon. Now, I think, unfortunately, most of us, I imagine, in this room will agree that now is not the time to go to the Supreme Court, right? To make our case before the Supreme Court. With all due honor to Justice Ketanji Brown Jackson. But the reality is, we made a lot of headway in getting the Supreme Court to adopt a reasonable child standard in the Supreme Court, to recognize that children were different from adults. We also got the Supreme Court to conclude that it was cruel and unusual punishment to impose the death penalty on young people who committed, or on anyone who had committed a crime while they were a minor. Unfortunately, I do not expect more of those victories anytime soon. However, our work in direct representation and in the local courts is more important than it has ever been. Young people, Black and brown youth, still need us to litigate race in state and local courts. So then what does that look like, you say? Well, it looks like another client that I represented with my law students, a client that I'll call Andre. Andre was a 15-year-old Black boy who was walking down the street in Washington, D.C. when a police car, at the time unmarked, drove up, rolled down the window, yelled out, and asked them, "Did you hear any gunshots?" Andre was with a friend, also 15, James. Both boys said, "No, we didn't hear anything," and they kept walking. The police officers weren't satisfied, and they continued to follow them and yelled out again, "Well, can I see your waistband?" For those of you who don't know what that means, some of you are nodding, Daniel Harar, who represents folks in the criminal system as well. What the officers were asking was for the young boys to lift their shirts so that they could see whether or not the boys had any weapons in their waistband. Both of the boys lifted their shirts. The officers didn't see anything. The boys kept on walking. The police officers are still not satisfied. And they say to them, "Well, can we search you?" At which point the boys say yes. The officers, 4 officers, get out of the car, have the boys put their hands up, pat them down. And I, as a defense attorney, a longtime defense attorney, am always baffled when anybody says yes to a consent to search, right? And when we asked Andre at the time of his arraignment, "Why would you agree to be searched?" And you all can imagine what he said. "Wouldn't you, Ms. Henning? If we said no, they were going to search us anyway, and if we tried to run, they would shoot us in the back." That is the state of children, Black children in urban and rural areas in our country. And so the question in Andre's case became whether or not the police and the reviewing courts should accept that as a valid consent. And you know I am really resisting the urge to do Socratic method and ask you for the standard, Dean McKenzie. No, just kidding. But, what is the standard for and I'll tell you who would know, Randy Hertz. But anyway, the standard for a valid consent. And it is that police must show that consent was freely given and not the result of express or implied duress. The basic Bustamante Supreme Court standard. But I have to tell you this. It wasn't until I became intentional, purposeful, on fire about litigating race that I realized or paid attention to this additional language, right? That the consent analysis also, or not only, involves some objective evaluation of the facts and circumstances, but it also must take into account, right, a subjective inquiry that takes into account personal experiences that drive fears and motivate people to act. The courts must also consider the possibly vulnerable subjective state of the person who consents. Is that not Andre? Right? Black and adolescents. And so this is how we litigate race, by educating judges and prosecutors and fact finders, jurors on how race and adolescence matters in our children's perceptions of and response to the police. Andre's story demonstrates how racial bias and the traumatic effects of policing in communities of color impact so many layers of the Fourth Amendment framework and other critical legal questions in the criminal law. It affects the seizure analysis, or in plain language, for those of you who are not lawyers, it affects this question of whether or not any reasonable Black child would ever feel free to decline to answer the question that the officer asked, whether any Black child like Andre would ever feel free to refuse that request to search or to lift up their shirt. It affects this race and traumatic effects of policing also affects our interpretation and our assignment of meaning to behaviors like flight, like nervousness, like furtive gestures by Black youth in the presence of police officers, right? It's not consciousness of guilt, it's fear and trauma. Fortunately, even as we lose ground in the appointment of federal judges in the coming days, coming weeks, a number of state high courts have still considered race and trauma, have begun to consider race and trauma and fear to be relevant in the determination of whether a reasonable person would have believed that they were free to leave or not. Similarly, a number of state high courts have also begun to acknowledge that flight alone from the police is not inherently suspicious, especially among Black and brown folks, and that innocent people sometimes flee from the police. Why? Because they are not only afraid of violence, but they're afraid of police corruption or resent police corruption, and they flee because they are afraid of being apprehended for something they did not do. Now, of course, these state and local successes are only possible when we have state judges that understand the issues, who are willing to acknowledge the impact of race and trauma on Black and brown folks, and who have the courage to apply the law in a way that accounts for that reality. So we all have to pay attention to those local elections, right? Pay attention to the election of judges and DAs. Now, beyond direct representation, our young people also still need us to fight for a holistic public health framework for safety, school safety, for public safety. A framework that seeks to cultivate meaningful relationships between adults and children. A framework that is racially just. Let me ask you, how many of you think that my client, Sharice, recognized that she was being treated differently? Yes. And Andre, they know it, they see it, right? We need a framework that seeks to restore those relationships in our society that have already been broken. And we need a framework that is trauma responsive on the ground, that looks like counselors and social workers and positive youth interventions and social workers and violence interrupters in those places where there really is violence. It means that we need to invest directly in youth and families and in communities, and not in law enforcement equipment and surveillance officers. But now, in this moment, maybe that will require us to look for private dollars instead of government funding. And I can tell you right now that the Office of Juvenile Justice and Delinquency Prevention is not coming to save our children after January 2020 or 2025. And we saw that in 2016. The effect was immediate for those of us who work in the juvenile legal system, when the Office of Juvenile Justice and Delinquency Prevention narrowed the reporting requirements on racial and ethnic disparities, and when it literally stripped implicit racial bias from training materials. I would go out into the field, and if any dime of the funding for that trip to do that speak or to give that talk was funded by OJJDP in that era, they were reviewing our slides in advance and precluding us to talk about race and bias. So maybe we need to look to foundations like the Public Welfare Foundation, among many others. Maybe we have to rely on mutual aid and Saturday schools like we did in the past. And our young people still need us to advocate for legislative and policy reform, but maybe we need to develop a new legislative agenda, a new creative legislative agenda. As Derek Bell said, racism will not be easily fixed with legislation. And as we lose what little ground we have had in equal protection and racial profiling, maybe we can make some headway by advancing and litigating the Americans with Disabilities Act, when state actors like teachers and police officers and correctional staff know that our young people have disabilities but choose to criminalize them instead. And so here I am thinking about the kinds of issues that have wider appeal across race and class, but yet will still have tremendous value and input, positive input or positive impact on young people, Black youth and brown youth in our society. I'm also thinking about a legislative agenda at the state level. Here I'm thinking about New York that just decriminalized jaywalking, right? I'm even thinking about South Carolina that finally legalized or eliminated the offense of disturbing schools. How many of you even knew that was a thing, right? A criminal offense to disturb schools. I feel like you look in the dictionary, disturb school, adolescents, by definition, right? But it was being disproportionately used against Black and brown youth. And this is these victories are the result of extraordinary advocacy, grassroots advocacy, legal advocacy at the state and local level. And even if we can't get state legislators to formally decriminalize normal adolescent behaviors, then what can we do in our local schools and neighborhoods and recreation centers and other youth-serving entities to educate decision makers about the patterns and the harms of criminalizing normal adolescent behavior? What can we do to get to get the critical decision makers to avoid punitive responses to emotional outbursts, to adolescent aggressive speech, to trauma responses, particularly among kids who are hurting so much right now? And then finally, if we really want to know how to make the world a better place for Black and brown children, then we have to ask them. And we start that work by acknowledging that the youth that we serve and that we care about have been harmed by racial injustice. We have to acknowledge that at the outset. Make sure that young people have culturally responsive mental health services in place. Again, now more than ever. We have to create space for young people to share their perspectives, their experiences, and their context, including experiences with race and discrimination. And then we have to sit back and listen, stating our intention to earn their trust and create an open and honest relationship, inviting them to hold us accountable when we get it wrong, right? When we have said something that is hurtful. And then we need to meaningfully implement their ideas. So I want to end where I began, which is with wisdom from Professor Derek Bell. We have to recognize injustice, stand up and speak out about those injustices in the face of what appear to be insurmountable odds. We have to fight for a world in which every single child has the right to be a child with all of the joy and laughter and creativity and experimentation and risk-taking and impulsivity that we enjoyed in our childhood. So I thank you very much for this opportunity. Thank you. Thank you.
Please join me in thanking Professor Chris Henning again for such a phenomenal lecture. It was insightful, revelatory, enlightening, brilliant, and uplifting all at once. Chris, you were truly a beacon, and I thank you for giving us all what we needed, particularly in these times. And thanks to all of you for attending this year's lecture. Before we part ways, I have a few kind of housekeeping matters to attend to. First, for those of you who are seeking CLE credits, don't forget to sign out on your way out of this room, this space tonight. This event will be available on the NYU School of Law YouTube channel in a couple of weeks, so if you know someone who unfortunately missed out on this brilliance tonight, they'll have an opportunity to see what they missed and be sorry that they missed it in person. And finally, just a few thank yous. You may have heard these names already, but I'm a firm believer in the fact that you can't be thanked enough. So you might hear some repetition. I want to first thank the incredible faculty, staff, and students at NYU Law. This is a wonderful community to be a part of. I want to extend a special thank you to Alyssa Ward, Ellie Fallon, Steve Killian, Nick Vigilatos, and the phenomenal people in the Office of Development and Alumni Relations who do so much work to put this incredible event together every year. So thanks to all of them. Thanks are also due to Dean Troy McKenzie and everyone in the Dean's office, as well as Randy Hertz, the ride or die Randy Hertz, and LACA for all of their unwavering support of this lecture over the years. And thanks to all of those who have prepared the food, who are going to serve us, who have set up this room and made this space such a beautiful space to be in together. I want to thank my center colleagues, Jason Williamson for his phenomenal leadership of the center, Tolu Lawal, Dejuna Seamus, Leila Al, Justine Olderman, and Andrew Friedman for all their tremendous work that they do every day to advance racial justice, as well as our student fellows, past and present, for all the work that they do day in and day out. I also want to thank the prior faculty directors. Tony Thompson was a founding faculty director of the center, and Deborah Archer, my colleague and friend as well, the tremendous Deborah Archer. Thanks to all of you. And thanks are, of course, due to Dr. Janet Bell, who conceived of this lecture series and has been a steadfast and unparalleled supporter over the years. As she mentioned, every Derek Bell lecturer has been, over these last 3 decades, or nearly 3 decades, prescient and consistently dynamic, speaking to the core challenges that we face as we navigate the indelible force of race in America. We owe a debt of gratitude to you for allowing us to be together and hear these lectures year after year after year, so thank you. So, speaking of which, these are undoubtedly difficult times, and difficult times ahead. They'll certainly get more difficult in the days and weeks and months and years ahead. And last week I found myself, even though we're a nonpartisan institution, reflecting on Professor Bell, and in particular, the final chapter of his incredible book, Faces at the Bottom of the Well, which you heard about earlier. And the chapter is entitled Beyond Despair, because quite frankly, I was in that space of despair, as I'm sure many others were. The chapter is written as a letter to the protagonist, lawyer, prophet, and heroine, Geneva Crenshaw. And as everyone in this audience understands, Professor Bell, his view was that racism is a permanent force in America. And there's plenty of evidence, I think, to back up that claim. Despair might be the way that one deals with such a hard-edged truth, but Professor Bell in this letter dispenses with despair immediately. He writes, "I'm reminded that our forebears, though betrayed into bondage, survived the slavery in which they were reduced to things, property, entitled neither to rights nor to respect as human beings. Somehow, as the legacy of our spirituals makes clear, our enslaved ancestors managed to retain their humanity, as well as their faith that evil and suffering were not the extent of their destiny, or of the destiny of those who would follow them. Indeed, we owe our existence to their perseverance, their faith. In these perilous times, we must do no less than they did. Fashion a philosophy that both matches the unique dangers we face and enables us to recognize in those dangers opportunities for committed living and humane service." He went on to write that in doing so, we are called to do what Black people, Latino people, and other people of color and disadvantaged and dispossessed by racism and inequality have always done. And I quote, "to make something out of nothing, carving out a humanity for oneself by deploying imagination, will, unbelievable strength, and courage. Beating the odds while firmly believing, knowing intimately, that all those odds are stacked against them. And in doing so, we remind the powers that be that out there are persons like us who are not only not on their side, but determined to stand in their way. I hope that you all find ways to cast away despair, to rest and rejuvenate, because rest is revolutionary, and to commit yourself to service, to frustrate the powers that be, by remembering that, as Professor Bell taught us, the struggle for freedom is a manifestation of our humanity that survives and grows stronger through resistance. We at the Center, along with so many others in this room and outside this room, will be doing that work. To paraphrase my brilliant colleague, Professor Archer, these are the times that we were all made for. And with that, I say thank you, good night, and God bless.